return to our desk.
The Senate will convene as a court of impeachment. The chaplain will lead us in prayer.
Let us pray. Divine Shepherd, honor, glory, and power belong to you. Refresh our senators as they enter a new phase of this impeachment trial. May they realize that you have appointed them for this great service, and they are accountable to you. Lord, empower them to labor today with the dominant purpose of pleasing you, knowing that it is never wrong to do right. Give them resiliency in their toil as they remember your promise that they will reap a bountiful harvest if they don't give up. Help them to follow the road of humility that leads to honor as they find their safety in trusting you. We pray in your majestic name. Amen.
Amen. Please join me in reciting the Pledge of Allegiance to the flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
If there is no objection, the journal of proceedings of the trial are approved to date. Without objection, so ordered. The Sergeant-at-Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment, while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
The Majority Leader is recognized.
Today, the Senate will conduct up to 8 hours of questions to the parties delivered in writing to the Chief Justice. As a reminder, the two sides will alternate and answers should be kept to 5 minutes or less. The majority side will lead off with a question from the senator from Maine.
Mr. Chief Justice,
The senator is recognized.
I send a question to the desk. On behalf of myself, Senator Murkowski, and Senator Romney.
This is a question for the counsel for the president. If President Trump had more than one motive for his alleged conduct, such as the pursuit of personal political advantage, rooting out corruption, and the promotion of national interests, how should the Senate consider more than one motive in its assessment of Article 1?
Mr. Chief Justice, Senators, in response to that question, there are really two layers to my answer, because I'd like to point out first that even if there was only one motive, the theory of abuse of power that the House managers have presented, that subjective motive alone can become the basis for an impeachable offense, we believe is constitutionally defective. It is not a permissible way to frame a claim of an impeachable offense under the Constitution. But I'll put that to one side and address the question of mixed motive. If there were a motive that was a public interest but also some personal interest, we think it follows even more clearly that that cannot possibly be the basis for an impeachable offense. And even the House managers, as they have framed their case, they have explained, and this is pointed out in our trial memorandum, that in the House Judiciary Committee report, they specify that the standard they have to meet is to show that this is a sham investigation. It's a bogus investigation. These investigations there's not any legitimate public purpose. That's the language, any legitimate public purpose. That's the standard they've set for themselves in being able to make this claim under their theory of what an abuse of power offense can be. So it's a very demanding standard that they've set for themselves to meet. And they've even said they came up and they talked a lot about the Bidens. They talked a lot about these issues in 2016 election interference, because they were saying there's not even a scintilla of any evidence of anything worth looking into there. And that's the standard that they would have to meet, showing that there's no possible public interest and the president couldn't have had any smidgen even of a public interest motive, because they recognize that once you get into a mixed motive situation, if there's both some personal motive but also a legitimate public interest motive, it can't possibly be an offense. Because it would be absurd to have the Senate trying to consider, well, was it 48% legitimate interest and 52% personal interest, or was it the other way? Was it 53% and 40%? You can't divide it that way. And that's why they recognize that to have even a remotely coherent theory, the standard they have to set for themselves is establishing there is no possible public interest at all for these investigations. And if there is any possibility, if there is something that shows a possible public interest, and the president could have that possible public interest motive, that destroys their case. So once you're into mixed motive land, it's clear that their case fails. There can't possibly be an impeachable offense at all. And think about it. All elected officials, to some extent, have in mind how their conduct, how their decisions, their policy decisions will affect the next election. There's always some personal interest in the electoral outcome of policy decisions. And there's nothing wrong with that. That's part of representative democracy. And to go start saying now that, well, if you've got a part motive that's for your personal electoral gain, that that's somehow going to become an offense, it doesn't make any sense. And it's totally unworkable. And it can't be a basis for removing a president from office. So the bottom line is, once you're into any mixed motive situation, once it is established that there is a legitimate public interest that could justify looking into something, just asking a question about something, the manager's case fails, and it fails under their own terms. They recognize that they have to show no possible public interest. There isn't any legitimate public interest. And they've totally failed to make that case. I think we've shown very clearly that both of the things that were mentioned, 2016 election interference and the Biden-Burisma situation, are things that raise at least some public interest. There's something worth looking at there. It's never been investigated in the Biden situation. Lots of their own witnesses from the State Department said that on its face it appears to be a conflict of interest. It's at least worth raising a question about, asking a question about it. And there is that public interest, and that means their case absolutely fails. Thank you.
Thank you, counsel. The Democratic leader is recognized.
Mr. Chief Justice, I send the question to the desk.
The Democratic leader asks the House managers. John R. Bolton's forthcoming book states that the President wanted to continue withholding $391 million in military aid to Ukraine until Ukraine announced investigations into his top political rival and the debunked conspiracy theory about the 2016 election. Is there any way for the Senate to render a fully informed verdict in this case without hearing the testimony of Bolton, Mulvaney, and the other key eyewitnesses, or without seeing the relevant documentary evidence?
Thank you, Mr. Chief Justice. The short answer to that question is no. There's no way to have a fair trial without witnesses. And when you have a witness who is as plainly relevant as John Bolton, who goes to the heart of the most serious and egregious of the President's misconduct, who has volunteered to come and testify to turn him away, to look the other way, I think is deeply at odds with being an impartial juror. I would also add in response to the last question that if any part of the President's motivation was a corrupt motive, if it was a causal factor in the action to freeze the aid or withhold the meeting, that is enough to convict. It would be enough to convict under criminal law. But here there's no question about the President's motivation. And if you have any question about the President's motivation, it makes it all the more essential to call the man who spoke directly with the President, that the President confided in and said he was holding up this aid because he wanted Ukraine to conduct these political investigations that would help him in the next election. If you have any question about whether it was a factor, the factor, a quarter of the factor, all of the factor, there is a witness, a subpoena away who can answer that question. But the overwhelming body of the evidence makes it very clear. On July 26th, the day after that phone call, Donald Trump speaks to Gordon Sondland. That's that conversation at Ukraine restaurant. And what does Gordon Sondland, what is the President's question of Gordon Sondland the day after that call? Is he going to do the investigations? Now, counsel for the President would have you believe the President was concerned about burden sharing. Well, he may have had a generic concern about burden sharing in other contexts. But here, the motivation was abundantly clear. On that phone with Gordon Sondland, the only question he wanted an answer to was, is he going to do the investigation? Now, bear in mind, he's talking to the ambassador to the European Union. What better person to talk to if his real concern was about burden sharing than the guy responsible for Europe's burden sharing? But did the President raise this at all? Of course not. Of course not. And if you have any question about it at all, you need to hear from his former national security advisor. Don't wait for the book. Don't wait till March 17th, when it is in black and white, to find out the answer to your question. Was it all the motive, some of the motive, or none of the motive? Now, we think, as I mentioned, the case is overwhelmingly clear without John Bolton, but if you have any question about it, you can erase all doubt. Now, let me show you a video, underscore number 2, slide 2, how important this is.
As House managers, really, their goal should be to give you all of the facts, because they're asking you to do something very, very consequential. And ask yourself, given the facts you heard today that they didn't tell you, who doesn't want to talk about the facts? Who doesn't want to talk about the facts? Impeachment shouldn't be a shell game. They should give you the facts.
Last video, which is even more important and on point for Mr. Bolton. Number 3.
And once again, not a single witness in the House record that they compiled and developed under their procedures that we've discussed and will continue to discuss provided any firsthand evidence that the President ever linked a presidential meeting to any investigations. Anyone who spoke with the President said that the President made clear that there was no linkage between security assistance and investigations.
No, that's not correct, right? Because, of course, Mick Mulvaney said that the money was linked to these investigations. He said, in acknowledging a quid pro quo, they do it all the time and we should just get over it. Gordon Sondland also said, the President said, on the one hand, no quid pro quo, but also made it clear that Zelensky had to go to the mic and announce these investigations.
Thank you.
Thank you, Justice.
Mr. Chief Justice,
Senator Thune.
I have a question for the President's counsel.
To the President's counsel, would you please respond to the arguments or assertions the House managers just made in response to the previous question?
Mr. Chief Justice, Senators, a couple of points that I'd like to make. Manager Schiff suggested that there was no evidence the President was actually interested in burden sharing because he didn't apparently, according to David Hale, raise it in the telephone conversation that he had with Gordon Sondland that Hale claims to have overheard at a restaurant in Kiev. But let's look at the real evidence. As we explained, on June 24th, there is an email in the record showing, it's an email from one person at the Department of Defense to another with a subject line of POTUS follow-up, President of the United States follow-up, asking specifically about burden sharing. It says, quote, what do other NATO members spend to support Ukraine, end quote. That was what they were following up on for the President. And in the transcript itself, excuse me, in the transcript of the July 25th call itself, the President asked, he said, we spend a lot of effort and a lot of time for Ukraine, much more than the European countries are doing, and they should be helping you more than we are. Germany does almost nothing for you. All they do is talk, and I think it's something you should really ask them about. And he goes on to say that he talks to Angela Merkel about it, and that they're not really doing as much as the United States is doing. He's raising burden sharing, and President Zelensky agreed with him. Now, Manager Schiff also suggested that there is evidence of some connection between the military assistance and investigations into 2016 election interference because of a statement that Acting Chief of Staff Mulvaney made at a press conference. But it's been clear in the record since that press conference that what he was saying was garbled and or misunderstood, and he immediately clarified and said on that day, quote, the President never told me to withhold any money until the Ukrainians did anything related to the server, end quote. And similarly, he issued a statement just the other day making clear again that he said, this is from his counsel, so it's phrased in the third person, nor did Mr. Mulvaney ever have a conversation with the President or anyone else indicating that Ukrainian military aid was withheld in exchange for Ukrainian investigation of Burisma, the Bidens, or the 2016 election. That is Mr. Mulvaney's statement. Lastly, onto the point of whether this chamber should hear from Ambassador Bolton. And I think it's important to consider what that means, because it's not just a question of, well, should we just hear one witness? That's not what the real question is going to be. For this institution, the real question is, what is the precedent that is going to be set for what is an acceptable way for the House of Representatives to bring an impeachment of a President of the United States to this chamber? And can it be done in a hurried, half-baked, partisan fashion without, they didn't even subpoena John Bolton below. They didn't even try to get his testimony. And to insist now that this body will become the investigative body, that this body will have to do all the discovery, and that this institution will be effectively paralyzed for months on end because it has to sit as a court of impeachment, while now discovery is done because it would be Ambassador Bolton, and if there are going to be witnesses, then the president would have to, in order, they said fair trial, fair adjudication, then the president would have to have his opportunity to call his witnesses. And there'd be depositions, and this would drag on for months. And then that's the new precedent. Then that's the way all impeachments operate in the future. The House doesn't have to do the work. They do it quick. They throw it over the transom, and this institution gets derailed and has to deal with it. And that should not be the way, that should not be the precedent that is set here for the way this body will have to handle all impeachments in the future. Because if it becomes that easy for the House to do it, they'll be doing it a lot. Thank you.
The senator from Massachusetts.
Send a question to the desk.
Question from Senator Markey to the House managers. On Monday, President Trump tweeted, "The Democrat-controlled House never even asked John Bolton to testify." End quote. So that the record is accurate, did House impeachment investigators ask Mr. Bolton to testify?
Senators, the answer is yes. Of course, we asked John Bolton to testify in the House, and he refused. We asked his deputy, Dr. Kupperman, to testify, and he refused. Fortunately, we asked their deputy, Dr. Fiona Hill, to testify, and she did. We asked her deputy, Colonel Vindman, to testify, and he did. But we did seek the testimony of John Bolton as well as Dr. Kupperman, and they refused. When we subpoenaed Dr. Kupperman, he sued us, took us to court. When we raised a subpoena with John Bolton's counsel, the same counsel for Dr. Kupperman, the answer was, Senator, you serve us with a subpoena and we will sue you too. We knew, based on the McGahn litigation, it would take months, if not years, to force John Bolton to come and testify. And I should point out, because I think this is an essential point to underscore, as the president's lawyers say, they didn't try hard enough to get John Bolton, or they should have subpoenaed John Bolton. That's what they're telling you. But let me show you what they're telling the court in the McGahn litigation. If we could pull up slide number 39. This is the president's lawyers in court in the McGahn litigation. In the Court of Appeals right now, quote, "The committee," meaning our committee, "lacks Article III standing to sue to enforce a congressional subpoena demanding testimony from an individual on matters related to duties as an executive branch official." I mean, it takes your breath away, the duplicity of that argument. They're before you saying they should have tried harder to get these witnesses, they should have subpoenaed, they should have litigated for years, and down the street in the federal courthouse, they're arguing, "Judge, you need to throw them out. They have no standing to sue to force a witness to testify." Are we really prepared to accept that? Now, counsel says, think about the precedent that we would be setting if you allow a House to impeach a president and you permit them to call witnesses. Well, I would submit, think about the precedent you will be setting if you don't allow witnesses in a trial. That, to me, is the much more dangerous precedent here. But I'll tell you there's something even more dangerous, and this was something that we anticipated from the very beginning, which is we understood when we got to this point they could no longer contest the facts that the president withheld military aid from an ally at war to coerce that ally to doing the president's political dirty work. So now they have fallen back on, you shouldn't hear any further evidence, any further witnesses on this subject. What's more, we're going to use the end-all argument, so what? A president is free to abuse their power. We're going to rely on a constitutional theory, a fringe theory, that even the advocate of which says is outside of the consensus of constitutional law, to say that a president can abuse his power with impunity. Now imagine where that leads. A president can abuse his power with impunity. Now, that argument made by Professor Dershowitz is at odds with the Attorney General's own expressed opinion on the subject, with Ken Starr's expressed opinion on the subject, with not only other counsel for the president, Jonathan Turley, who testified in the House, says that theory is constitutional, effectively nonsense. But even 60-year-old Alan Dershowitz doesn't agree with 81-year-old Alan Dershowitz. And for a reason, because where that conclusion leads us is that a president can abuse his power in any kind of way, and there's nothing you can do about it. Now, are we really ready to accept the position that this president or the next can withhold hundreds of millions of dollars in military aid to an ally at war unless they get help in their reelection? Would we say that you could, as president, withhold disaster relief from a governor unless that governor got his attorney general to investigate the president's political rival? That, to me, is the most dangerous argument of all. It's a danger to have a president who would engage in this conduct. It's a danger to have a trial with no witnesses and set that precedent. But the biggest danger of all, I think, would be to accept the idea that a president can abuse his office in this way, and the Congress is powerless to do anything about it. That is certainly not what the founders intended.
Mr. Chief Justice.
The senator from Tennessee.
Thank you, Mr. Chief Justice. I send a question to the desk on my behalf and also joined by Senators Loeffler, Lee, Kramer, and McSally.
The senators ask of counsel for the president, is the standard for impeachment in the House a lower threshold to meet than the standard for conviction in the Senate? And have the House managers met their evidentiary burden to support a vote of removal?
Mr. Chief Justice, Senators, the standard in the House, of course, the House is not making a final determination in the structure of the Constitution. An impeachment is simply an accusation. And as in most systems where there is simply an accusation being made, the House does not have to adhere to the same standard that is used in the Senate. In most instances, House members have suggested in debates on articles of whether or not to approve articles of impeachment that they should have clear and convincing evidence in the view of the members voting on it that there was some impeachable offense, and that is all. Some not even that standard. And so it is simply enough evidence that an accusation can be made. It is definitely a lower standard than the standard that has to be met here on a trial for an ultimate verdict. The Constitution speaks in terms of a conviction in the Senate. And as both Professor Dershowitz and Judge Starr pointed out in their comments, everywhere in the Constitution that there's any mention of impeachment, it is spoken of in terms of the criminal law. The offenses that define the jurisdiction for the Senate sitting as a court of impeachment are treason, bribery, and high crimes and misdemeanors. The Constitution speaks of a conviction upon being convicted in the Senate. It speaks of all crimes being tried by jury except in cases of impeachment, again suggesting notions of the criminal law. And as we pointed out in our trial memorandum, all of these textual references make it clear that the standards of the criminal law should apply in the trial, certainly to the extent of the burden and standard of proof to be carried by the House managers, which means proof beyond a reasonable doubt. And it is very clear that there is not any requirement for proof beyond a reasonable doubt simply for the House to vote upon articles of impeachment. There's a very much higher standard at stake here. As we pointed out in our trial memorandum, the mere accusation made by the House comes here with no presumption of regularity at all in its favor. The Senate sits as trier of both fact and law, reviewing both factual and legal issues de novo, and the House managers are held to a standard of proving proof beyond a reasonable doubt of every element of what would be a cognizable, impeachable offense. Here, they have failed in their burden of proof. They have also failed on the law. They have not stated in the articles of impeachment anything that on its face amounts to an impeachable offense. And on the facts, I think we have demonstrated very clearly that they have not presented facts that would amount to an impeachable offense, even under their own theories. They have presented only part of the facts and left out the key facts. And Mr. Papura, I think, went through very effectively showing that there are some facts that don't change. The transcript of the July 25th call shows the president doing nothing wrong. President Zelensky said he never felt any pressure. His other advisors have said the Ukrainians never felt any pressure. They didn't think there was any quid pro quo. They didn't even know that the military assistance had been held up until the Politico article at the end of August. The only two people with statements on record who spoke to the president, who are Sondland and Senator Ron Johnson, report that the president said to them there was no quid pro quo, and the aid flowed without anything ever being done related to investigations. That is what's in the record. That is what the House managers have to rely on to make their case, and they have failed to prove their case beyond a reasonable doubt, failed even to prove it by clear and convincing evidence, failed to prove it at all, in my opinion. Thank you.
Thank you, counsel. The senator from California is recognized.
Thank you. Mr. Chief Justice, I send a question to the House managers.
Senator Feinstein asks the House managers. The President's counsel stated that, quote, there is simply no evidence anywhere that President Trump ever linked security assistance to any investigations, end quote. Is that true?
Thank you, Mr. Chief Justice, and thank you, Senator, for that question. The President's counsel is not correct. There is, in fact, overwhelming evidence that the President withheld the military aid directly to get a personal political benefit to help his individual political campaign. There's a few points that I'd like to submit for your consideration. First, look no further than the words of the President's acting Chief of Staff, Mick Mulvaney, who on October 17th, 2019, during a national press conference, mentioned, quote, or he was asked about the direct connection between the aid, and he said, quote, did he, meaning President Trump, referring to he, quote, also mentioned to me in passing the corruption related to the DNC server? Absolutely, no question about it, but that's it. And that's why we held up the money, end quote. He was repeating the President's own explanation relayed directly to him. Second, Gordon Sondland testified he spoke by phone with President Trump on September 7th. The President denied there was a, quote, quid pro quo, but then outlined the very quid pro quo that he wanted from Ukraine. Then he told President Sondland to, quote, that President Zelensky should, quote, go to the microphone and announce the investigations. He should want to do it. Third, the president's own advisors, including the Vice President and Secretary Pompeo, were also aware of the direct connection. In Warsaw on September 1st, Ambassador Sondland told Vice President Pence that he was concerned the delay in security assistance had become, quote, tied to the issue of investigations. The Vice President simply nodded, tacitly acknowledging the conditionality of the aid. Fourth, we heard from Ambassador Taylor, who in direct emails and texts said it was crazy to tie the security assistance to the investigations. 5, we also know there's no other reason. The entire apparatus and structure of the Defense Department, the State Department, that should have been dealing with the other legitimate reasons, the policy debate that the President's Council wants you to believe that this was about, they were all kept in the dark. And the supposed interagency process that they made up several months after the fact had ended months before, during the last interagency meetings. And I'll make one final point. Again, if you have any lingering questions about direct evidence, any thoughts about anything we just talked about, anything I just relayed, or that we've talked about the last week, there is a way to shed additional light on it. You can subpoena Ambassador Bolton and ask him that question directly.
Thank you, Mr. Manager.
Mr. Chief Justice,
Senator from Utah.
I send a question to the desk.
Senator Lee asks of counsel for the President. The House managers have argued aggressively that the President's actions contravened U.S. foreign policy. Isn't it the President's place, certainly more than the place of career civil servants, to conduct foreign policy?
Thank you, Mr. Chief Justice, Senators, and thank you for that question. It is definitely the President's place to set U.S. foreign policy, and the Constitution makes this clear. Article 2, Section 1 vests the entirety of the executive authority in a President of the United States. And it's critically important in our constitutional structure that that authority is vested solely in the President, because the President is elected by the people every 4 years. That's what gives the President democratic legitimacy to have the powers that he is given under the Constitution. Our system is somewhat unique in the very broad powers that are assigned to the executive, but it works and it makes sense in a democratic system precisely because he is directly accountable to the people for the policies